The event held on the following days. The qualifier round of the Moot Court, Law Quiz and Think Logical was held on 10th of February 2022. Then the qualifying teams competed for the semi-final round on 11th of Feb 2022 and the C-Spot Save was also held on 11th of Feb 2022. Furthermore, today the qualifying teams are going to compete for the final Moot Court and Law Quiz. So all the best to everyone. Sharanya, please continue and proceed with the further program.
Thank you so much, Tejal ma'am. Indeed, your support was a backbone to us. I request our IC principal, Madhura Karamkar ma'am, to have a few words and welcome our chief guest.
Thank you, Sharanya. A very warm and a grateful morning to all the dignitaries, our Honorable President, Dr. Rajendra Singh sir, our Director, Dr. Usha Mukundan madam, Management Committee, respected principals, teachers, participants, and my dear students, and everyone who gathered on this online platform. On behalf of Hindi Vidya Prachar Samiti College of Law, I, Dr. Madhura Mangesh Kalamkar, welcome you all today for our last day of fest, VidhiTaksh. So I'm really very much thankful for our first day judges, Advocate Prakash Salsingikar sir, Advocate Suvarna Awardwat sir, our second day's judge, Advocate Dharmesh Mehta sir, who spared time from their busy schedule to grace the occasion, not only as a moot court judge, but they imparted their knowledge during the online competition to the participants and also to our students by sharing the actual process observed in the court of law. Today, we have with us Advocate Aruna Pai ma'am, Public Prosecutor of High Court, Criminal Side, to grace the occasion and for judging today's final round. So I welcome you ma'am on behalf of Hindi Vidya Prachar Samiti's College of Law. So students, today we have an opportunity to hear respected ma'am's thoughts, and this will surely be going to encourage participants and our students in their future events. I would also like to thank the students who firstly prepared the moot court propositions, Shivang Tiwari, Narayan Mishra, and Shreya Iyer. I therefore also hereby acknowledge the contribution those who worked behind the scene to make this event happen 3 days of fest VidhiTaksh successfully till now by our General Secretary Sharanya Vats, Deputy Secretary Riddhi Gupta, Treasurer Reena Kotia, and all their team and my students who are really working from last months for the successful celebration happen, as the program is very well arranged and enjoyed by each one of us present here. So thank you, and I will request our General Secretary Sharanya Vats to carry on with the program. Thank you all.
Thank you so much, ma'am. Thank you so much for your support for this program and forever. Without any further programs, we shall start with the moot court competition final round, VTM 05 versus VTM 03. We have Aruna Pai madam, the Chief PP of High Court, to judge you all, and we shall start. The prosecution shall go first. Let me tell you the rules of the competition. So each team will have 40 minutes. The division for it would be 12.5 mooter 1 shall present its arguments. The next 12.5 minutes, mooter 2 shall be presenting its arguments, and 15 minutes shall be given for chief and cross respectively. The participants are requested to keep their cameras on. The participants shall adhere to the black and white uniform. Any violation in the rules shall lead to deduction of marks. We are ready to go. Prosecution goes first.
Court officer, I just have a question.
Yes.
Can the time between both the speakers be adjusted? For example, one speaker takes more than 12.5 and the other speaker takes less than 12.5 to complete the total 25 minutes.
No, time has been allotted accordingly. So speaker 1 is requested for 12.5 minutes and speaker 2 shall adhere to 12.5 minutes.
Okay, noted. Thank you.
Yeah, thank you.
May I proceed? May it please the Honorable Court, I am the prosecutor appearing on behalf of state. May it please the Honorable Court, may the prosecution proceed with the statement of jurisdiction?
Yes, you may proceed.
Much obliged, ma'am. That this present case is filed in lieu of offence committed under section 300, 302, 324, 34 and 201 of the Indian Penal Code 1860. That the offence committed by the accused is classified as cognizable and non-bailable. That the offence committed under section 300 is punishable with death, imprisonment for life and also liable to fine under section 302. That the offence committed by the accused under section 302 under section 26 reference with first schedule of the Code of Criminal Procedure 1973 is triable by the Court of Session. Hence, this Honorable Court has complete jurisdiction over the present case to which the prosecution humbly submits. If the Honorable Court is well versed with the facts of the case, the prosecution would like to proceed with the issues and arguments.
You may proceed.
Much obliged, ma'am. I would like to proceed with the first issue, whether the prosecution has been able to prove the guilt of the accused beyond reasonable doubt. Our explanation is yes, the accused number 2 and accused number 1 are jointly and severally guilty for the murder of deceased Rampal Singh. That the accused number 1 and accused number 2 being educated and shared a good bond with each other. Also, accused number 2 confessed his love to accused number 1. Thereafter, accused number 1 came in extramarital affair with accused number 2. Deceased came to know about the extramarital affair of accused number 1 and accused number 2. So, accused number 1 and accused number 2 hatched a devious plan of murdering the deceased in cold blood, and getting rid of the deceased meant removal of the hurdle between their relationship. When deceased saw accused number 1 and accused number 2 together in his house, deceased left the house in anger. After the deceased left the house, accused number 1 went to market and bought butcher knife, ration, vegetable, meats and medicines, including sleeping pills, band-aid and painkiller, which was prescribed by Dr. Sudarshan Nayak on 9th November 2021 at 11 a.m. When deceased reached at home 10 p.m. on 9th November 2021, accused number 1 was waiting for deceased. Accused number 1 tried to talk and convince deceased that he misunderstood the situation about accused number 1 and accused number 2 at that time on 9th November. Also, accused number 1 assured deceased for discontinuation of communication between accused number 1 and accused number 2. Thereafter, accused number 1 cooked food deceased and accused number 1 ate food and went to bed. Accused number 1 mixed sleeping pills in deceased food. So accused number 1 and accused number 2 can successfully complete their plan of killing the deceased. Accused number 1 and accused number 2 used butcher knife to slit the throat, and once the victim died, accused number 1 and accused number 2 cut his body in 3 parts, packed the body parts of victim in gunny bags, dig a hole and buried the body parts and other instruments used like cement tiles to cover the dig hole. Accused number 1, after getting into extramarital affair with accused number 2, behaved differently with deceased by evading the question and giving unsatisfactory answer to the deceased questions. Accused number 1 used to spend more time with accused number 2 as noticed by informants from Indra Nagar Mohalla, naming Pooja, Sultan and Javed Sheikh. After no calls from few days from deceased to complainant Arun Singh, deceased brother, complainant in a concern on 19th November 2021 visited house of deceased and accused number 1 and asked accused number 1 about deceased, to which accused number 1 responded in very calm way that deceased has left for Sorat on 10th November 2021 morning at 6:30 a.m. for purchasing merchandise for company work, and his phone is not reachable due to network issue. Also, when Arun, the complainant, asked accused number 1 about her phone, accused number 1 gave an excuse of her phone is not in working condition, hence given it for repair. That eyewitness Komal, daughter of deceased and accused number 1, recorded statement, मुझे कुछ नहीं पता, मम्मी ने जैसे पापा को बेड के नीचे डाला मुझे भी डाल देगी. That recovery of murder weapon from crime spot, butcher knife, Amba Medico's bill of 9th November 2021, mentioning sleeping pills, painkiller and band-aid, medicine prescription by Dr. Sudarshan Nayak, cut body parts in gunny bags, broken tiles, deceased shirt with blood stain on it. Exhibit A, FIR under section 154 CRPC, FIR number 206/21, dated 24th November 2021, stating Surekha Singh as accused number 1 and Mohan Prakash as accused number 2 for the murder of victim Rampal Singh by Ayo Jayant Pawar. Exhibit 2, postmortem report dated 25th November 2021 by SI Hardik P and Dr. Ajay Matre, Dr. Senior Autopsy and Forensic, stated death caused due to slit of throat. That the Honorable Supreme Court in Ram Naresh and Osh versus State of Chandigarh had laid down 5 principles that are to be followed as guidelines by the court across India for determining whether death sentence is to be awarded or not. The court must use this standard to decide if this was the rarest of rare case in which a death sentence should be imposed. The court believes that any further sentence, such as life imprisonment, would be insufficient and would not serve the interest of justice. The death penalty is an exception rather than the norm. Given the nature and circumstances of the crime, as well as other relevant considerations, the options of imposing a life sentence cannot be used with cautions. The technique, planned or otherwise, and mannered, amount of violence and inhumanity, etc., in which the crime was prepared, as well as the circumstances surrounding its occurrence, need to be taken into account. May I please, Honorable Court, my friend would like to continue with the statement of issues 2 and 3.
May it please the Honorable Court. is if it is well versed with the issue number 1, the prosecution would like to proceed with this issue number 2.
You may proceed.
Much obliged. Issue number 2, whether the prosecution has been able to prove the guilt of accused number 1 and accused number 2 for the offense committed under section 201 of Indian Penal Code 1860. The answer is yes. The prosecution has been able to prove the guilt of accused number 1 and accused number 2 for the offense committed under section 201 of Indian Penal Code 1860 as follows. The deceased has caught accused number 1 and accused number 2 together inside the house. Thereafter, deceased left from there with the upset mind. Accused number 1 and accused number 2 made a plan to kill Rampal, that is deceased, as he is the only milestone between accused number 1 and accused number 2. Accused number 1 was well aware of the financial status of accused number 2, as accused number 2 used to give gifts on frequent basis to accused number 1. So in the greed of better status, accused number 1 was highly attracted towards accused number 2. Accused number 1 agreed to execute the plan of killing Rampal, that is deceased, in alliance with accused number 2. On 9th November 2021, accused number 1 went to market to bring ration, vegetables, meat. Along with this, she also bought butcher knife and medicines like painkiller, sleeping pills, and band-aid from Amba Medicos prescribed by Dr. Sudarshan Naik. At the night, when deceased came home, accused number 1 started to execute devious plan of cold-blooded murder to get rid of deceased. Accused number 1 tried to have a conversation with deceased to make deceased calm down. So accused 1 can execute step 2 by mixing sleeping pills in food and serving the same food to Rampal, that is deceased.
2 minutes left.
After Rampal and prosecution witness 2, that is Komal Singh, ate food and slept, accused number 2 entered the house. Accused number 1 and accused number 2 jointly slit the throat of Rampal and let him to die, after which the accused number 1 and accused number 2 chopped the body parts of Rampal in 3 parts and placed the body parts in the gunny bag, dug a hole under the bed in deceased house only, and buried the body parts and weapons in hole and concealed it using cement and tiles. When Arun, deceased brother, arrived at deceased house on 19th November 2021 and asked accused number 1 about the deceased, accused number 1 gave false information to Arun, saying deceased has went to Surat for company work. But when Arun's brother, deceased brother, inquired with prosecution witness 3, Viju, the proprietor of New Trends Garment, replied he is not aware about anything about deceased, as he has not seen him since 10th November 2021. The petitioner or complainant, based upon the evidences cited above, has proved beyond reasonable doubt the guilt of both accused jointly and severely in committing the crime and act which attracts the severest punishment under section 201 of the Indian Penal Code 1860. May it the Honorable Court is well versed with the issue number 2. The prosecution would like to proceed with issue number 3.
You may proceed.
Much obliged. Whether the accused has been able to prove beyond reasonable doubt that the deceased is not Mr. Rampal Singh. No, the deceased body is of Rampal Singh only. That as per the statement given by PW2 and accused number 1 and accused number 2 were seen together in deceased house. And accused number 2 was holding knife in hand. Both accused number 1 and accused number 2 were putting something in gunny bag. That the chopped body parts of the male body recovered was in gunny bags, which was concealed under the bed inside deceased house. That the concealed work done under the bed
Time
was
up.
not matching. Ma'am, I am speaker number 2. I guess the time is up for speaker number 1. May I proceed?
Yes, please.
Much obliged. That the concealed work done under the bed was not matching with the overall flooring. That as per the statement given by prosecution witness 1, Javed Sheikh, the deceased was last seen by prosecution witness 1 on 9th November 2021 at 10 p.m. when the prosecution witness 1 dropped deceased at home after the drinks they had at the restaurant bar. That as per the statement of accused number 1, the deceased had left for Surat for the purchase of merchandise of shop New Trend Garments House with prosecution witness 1 on 10th November 2021 at 6:30 a.m., which seems to be a false statement or contradicts the statements given by PW1 and PW3. That as per the postmortem report, the body found had contains of olpadium tartrate that the accused number 1 had purchased from Amba Medicos on 9th November 2021. Also, the age of deceased according to the postmortem report is 32, which is confirmed from the statement given by the accused number 1. That as per the statement given by the prosecution witness 2 on asking about the deceased, the accused number 1 replied in anger that she will kill me and put me under the bed where my father is otherwise. I should keep my mouth shut. Hence, the investigation that the body found is of Rampal Singh only. The petitioner or complainant, based on the evidences cited above, has proved beyond reasonable doubt that the body was discovered under the concealed flooring under the bed at deceased house is of Rampal Dilip Singh only and no one else. May it please the Honorable Court is well versed with the issue. The prosecution would like to proceed with chief examination of the witness.
Yes, you may proceed.
Much obliged. I would like to call prosecution witness number 2, Komal Rampal Singh.
Hello, am I audible?
Yes, Komal, you are audible. May I proceed?
Yes, yes, you may proceed.
Much obliged. Komal, what is your full name and age?
Komal Rampal Singh. I'm 11 years old.
Okay. Komal, do you know the meaning of oath?
No.
Okay. Let me explain. Oath means you cannot lie to the questions that are asked. Is it understood?
Yes.
Okay. Komal, do you go for karate classes?
Yes.
Okay. Komal, after you woke up on screaming sound, what did you see?
I saw my mom, Mohan uncle with knife, putting something in a gunny bag. I asked my mom, so she angrily said not to ask anything or otherwise she will bury me under the bed where my father is otherwise.
Okay. Komal, have you seen your father upset in recent days?
I'm not sure.
Okay. Do you know Ved Prakash?
Yes.
Okay. That's it for Komal Singh. I would like to call Chief Examine Prosecution Witness number 5, that is Ayo Jain Pawar.
Hello, am I audible?
Yes. May I proceed?
Yes, yes, you may proceed.
Much obliged. Mr. Jain Pawar, what action did you take after the complainant being filed by the complainant?
So there were two complaints filed, which I was talking about. One was missing report and one was the FIR.
Can you describe about the both of them?
Okay. So when the missing report was filed on 22nd of November, I sent an investigation team to investigate about the missing person. And after that, on 24th of November, when the FIR was filed, we called the accused and then we took their statement and also made an interrogation in their neighborhood.
Okay. Next question. What all was recovered from the crime spot in the investigation, ongoing investigation?
There were three goonie bags with bloodstain on it, a butcher knife, a box of used tiles, a goonie of cement, 3 dismembered body parts.
Okay. From where did you discover the corpse? Or okay, from where did you discover the corpse?
Sorry, could you repeat?
From where did you discover the corpse?
Can you repeat?
Okay, I'll simplify the question.
He's asking from
from
where did you discover the dead body?
Under the bed at the crime
Yes.
scene.
Okay. What or who led you to the place where the dead body was found?
While I was taking the statement of accused number 1 and 2, Mr. Arun, the brother of deceased, he came with Komal, the 11 years old daughter of the deceased, and the 11 years old daughter said that मुझे कुछ नहीं पता, जैसे मम्मी ने पापा को बेड के नीचे डाल दिया वैसे मुझे भी डाल देंगे. After hearing that, with an investigation team, I went to the scene and I recovered the body.
Okay. Next question. When you recovered the dead body from crime spot, what was its condition?
It was dismembered in 3 parts.
Okay. That's it from prosecution witness 5. Now my co-prosecution will continue.
May I please the Honorable Court to call petitioner witness number 1, Javed Sheikh, for chief.
Am I audible?
Yes. Mr. Javed Sheikh, could you please let know the court, when did you see deceased for the last time?
On 9th November.
Can you please be a bit specific? 9th November, at what time?
2021. At time, the last was 10 p.m.
Okay. That's all, Mr. Javed. Thank you so much. May I please the Honorable Court to call petitioner witness number 3, Biju, the proprietor of Government Rent House.
One correction, it should be prosecution witness, not petitioner witness. You should say prosecution
My apologies.
witness.
Apologies, ma'am.
And in criminal...
So may I call upon prosecution witness number 3?
Yes, and in criminal trials, can you hear me? Criminal trials,
Yes,
there
ma'am.
is no petitioner. it's always state, that is complainant, versus the defense, accused. Okay, so please bear this in mind. There's no petitioner,
Okay, thank you.
and it is prosecution witness.
Sure, ma'am. Thank you so much. So, ma'am, if you allow, may I call upon prosecution witness number 3, Viju?
Yes, yes, you may proceed.
Am I audible?
Much obliged, ma'am. Yes. Mr. Viju, since when do you know deceased?
Your voice is not audible. Hello?
Am I audible now?
Yes.
Could you please let the court know since when do you know deceased?
From last 1 year.
Okay. As part of their employment, was the deceased often sent out of town?
Yes.
Normal, for how many days you used to send deceased and Javed Sheikh Sorat for merchandise purchase?
For 1 month.
Okay. And when did you last send deceased to Sorat for merchandise purchase?
I don't recollect now.
Hello?
Hello. I'm not able to recollect now.
And for how many times you used to send deceased for to Sorat for merchandise purchase?
In 1 year, 3 times.
And when did you see deceased for the last time?
On 9th of November.
Okay. Thank you so much, Mr. Viju, for the statements. May it please the Honorable Court, the prosecution would like to proceed with the prayer.
Proceed.
Much obliged. In the lights of the facts pleaded, issues raised, arguments advanced, and evidence produced before the Honorable Court, the prosecution humbly prays that the accused has committed the heinous actress of murdering an innocent adult and attempting to murder an individual has been proved beyond reasonable doubt, that the accused had mens rea behind their actions has been proved beyond reasonable doubt on grounds of the fear of getting separated from each other, that the accused have a mindset of soul foul nature, such foul nature that they could go to any extent to achieve their selfish end and are a blot on humanity has been proved by the facts that accused has hatched a devious plan of murdering the deceased in a cold blood and getting rid of the deceased meant removal of the hurdle between their relationship, that the magnitude and the chilling nature of the crime of the accused is such that it has sent shivers down the spine and the accused are a threat to others and hence should be permanently removed from the civilized society, that the accused now being parents are also a threat to the welfare of their own child and are likely to bring up with the same cold mentality or be a threat to even their life. Accused number 1 and accused number 2 have tarnished humanity by not killing the victim but by mutilating his body and robbing him of dignity even in death. That this case fit into the rarest of rare category and hence the Honorable Court must not show any leniency to the accused and convict the accused under section 302, 34, 201 and 324 of IPC, sentence them to death so as to do justice to the deceased and to set an example that would deter people from committing similar act of such unimaginable, inhuman and horrific in nature. The petitioner would like to rest the prosecution side, ma'am.
A very good morning. The counsel for the defense seeks permission to begin with their case. Hello. Am I clearly audible and visible?
Yes, you are audible and visible. You may proceed.
Much obliged. May it please the Honorable Court, the counsel seeks permission to address the court as Your Honor.
Yes.
Much obliged, Your Honor. Your Honor, if Your Honor is well versed with the facts and issues at hand, the counsel humbly seeks permission to move ahead with the contentions at hand.
Yes, you may proceed.
Much obliged, Your Honor. Your Honor, the very first issue is whether the accused in this case are guilty of murder and all the other charges as stated in the first information report. It is humbly submitted in the negative that the alleged accused are not guilty of the offenses under section 302 read with section 34, section 324 and section 201 of the Indian Penal Code. This can be proved by the following facts which are material to the case. According to the forensic report, the date of death is 9th of November. However, the forensic report raises certain questions. The first off, since the date of death is 9th, it should have been 16 days since the time of death. However, the autopsy report shows that it has been 25 days since death. Your Honor, it is a proven fact that the stage of autolysis commences soon after death. The report states that the body is in rigor mortis. The body, this means the body has only been recovered between 24 to 84 hours maximum since the time of death. Hence, the date of death cannot be counted as the 9th of November. The external examination report states that the body is in full rigor mortis, and the internal examination states that the internal organs are in the process of autolysis. Your Honor, autolysis is the very first step of rigor mortis. It occurs within the few hours of death and lasts to the maximum period of 84 hours post-mortem. 84 hours, Your Honor, is the maximum period considering the slowest rate of decomposition. Full rigor mortis can only be achieved after autolysis has completed. The date of death on the autopsy report is shown as 9th. The body was recovered on the 24th. It means that 16 days has been passed after death. Following this timeline of the forensic and the FIR, the body should have passed the stage of autolysis and should have entered the stage of putrefaction. The 4 stages after death are called pallor mortis, alba mortis, rigor mortis, liver mortis, and putrefaction is followed by all of these 4 stages. All these 4 stages commence and are completed within 4 to 10 days maximum, and putrefaction commences within that period. After 10 days, the stage of black putrefaction begins, wherein noxious odors are released from the body and the parts of the body undergo a black discoloration. In this case, Your Honor, the autopsy report indicates only slight traces of decomposition externally and autolysis for the internal organs. This shows that the body has not been dead for over 5 to 6 days at the max. This shows that the murder has also not taken place on the 9th of November. Therefore, the murder should have taken place between 19th to 24th of November, that is after Arun's arrival to Mumbai. Therefore, the accused in the case are innocent and are wrongly being accused of committing the murder. Your Honor, Surekha and Mohan have been accused of first committing the murder, then digging the ditch under the bedroom floor and dissecting Rampal's body, then burying it under the ditch. My learned friends of the prosecution imply that the alleged accused have successfully hidden Rampal's body for over 2 weeks without anyone noticing. But they have kept other material evidences hidden in plain sight. My learned friend imply that the alleged accused have committed the murder, but they have neglected the evidence to such an extent that they have not even washed the butcher's knife after 16 days. it is humbly brought to the attention of the Honorable Court that a person taking utmost efforts to hide the body cannot make a mistake of letting material evidences be seen in plain sight. These so-called evidences have been carefully planted to frame Mohan and Surekha and to show that they were not merely friends but more. Any normal human conscience would want to destroy all such material evidences. Moreover, for these evidences have not been sent to the forensic laboratory. There is no mention in the forensic report about the weapon used to commit the murder. Similarly, there has been no mention about fingerprints, blood stains, etc. on the site of the murder that should have been splattered on the wall and the flooring. The knife is allegedly blood-stained, but no further analysis was conducted to check whether whether the blood belonged to the victim or whether it actually did belong to a human being as well. The forensic study can determine what kind of a weapon was used, whether it was sharp, whether it was blunt, how many blows were required to dissect the lower limbs of a male. No such mention has been given by the forensic report and the department. Your Honor, in the case of Govindaraju versus the state, it was held that no efforts were made to produce the final reports of the witness of the weapons from the forensic lab. Later on, it was found that the investigating officer did not send these recovered items for analysis. The court held that the prosecution were not able to prove the commission of the crime beyond reasonable doubts and the defendants were acquitted for the same. Similarly, in this case, the prosecution suffers from improbabilities, infirmities, and contradictions. Moreover, after analyzing the facts of the case, it seems as if these objects were planted at the site in question to seem like evidences and to make Surekha and Mohan look like they are guilty of causing murder of Rampal Singh. Your Honor, due to putrefaction, the entire room must reek after 16 days, as per the forensic report. But in reality, that was not at all the case. Moreover, the alleged evidences like knife, tools, gunny bags, cement bag, etc. were easily found, but the body had to be dug out of the flooring. My learned friend also implies that zolpidem was administered to the witness by the alleged accused. However, the counsel humbly places before the Honorable Court that one dose of zolpidem is 10 mg, which has to be taken per day. It has been 16 days since the death of murder when the strip was found. Only 4 tablets were left in the strip. This means out of 20 tablets, 16 tablets were taken by Surekha for her insomnia condition. It were not administered to the accused. If, according to my learned friends, 6 doses of zolpidem were administered to the victim should have died then and there. There was no need to slit his throat. There was no need to dissect his body parts. Also, Your Honor, my learned friend uses the theory of gunny bags. They say that they committed the murder. They dissected the body parts. They put it in the gunny bags and then they put it in the floor. Your Honor, if the murder has taken place over there, there is absolutely no requirement of putting it in the gunny bag and then burying it down. Also, my learned friend mentioned the theory that the tiles were not matching. Your Honor, please, the counsel for the defense humbly implores the Honorable Court that the counsel is misleading the court. There is no mention of the tiles not matching. Therefore, Your Honor, it is humbly submitted to the court that the accused in this matter are innocent and should not be convicted under the said charges. If Your Honor is satisfied with the contention for issue number 1, counsel number 1 seeks permission to briefly explain issue number 2 as well.
Now, before we go to issue number 2, tell me about the eyewitness, the child of 11 years old, who has been examined by the prosecution. What you have to say about that witness?
Yes, Your Honor. The issue number 2 is about the witness itself.
Okay, you proceed.
Much obliged, Your Honor. Your Honor, Section 118 of the Indian Evidence Act 1872 lays down that all persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put forth to them or from giving rational answers to those questions by means of tender years, extreme old age, disease, whether of body or mind, etc. Here, the witness is a minor and is also a mental patient. She has schizophrenia. Your Honor, the symptoms of schizophrenia are hallucinations, disoriented thoughts, delusions. Therefore, this statement also cannot be completely relied upon. In the case of State versus Allen, it was held that the courts consider 5 factors for determining the competency of a child. Absence,
2 minutes left.
absence of any one of them renders the child incompetent to testify. These factors are the understanding of the obligation of the oath, mental capacity at the time of occurrence of the event, a memory sufficient to retain an independent recollection of occurrences, the capacity to express in words or memory of the occurrence, and the capacity to understand the questions simply put forth before them. Your Honor, my learned friends of the prosecution have asked one question to the witness. The witness has repeatedly said that she is not well versed, she is not well aware about the same, she does not recollect it, she does not remember. Your Honor, the third condition for this is a memory sufficient to retain an independent collection of the occurrence. The counsel humbly submits that the witness does not have a memory sufficient to retain an independent recollection of occurrences. Also, in the present case, the investigating officer relied upon the statement given by the daughter of the deceased, who is merely 11 years of old, and it was initially given to the uncle, not to the police officers. Therefore, Your Honor, the counsel seeks permission to conclude issue number 2 and further explain it during the cross-examinations. If Your Honor is satisfied with the statement of contentions for both the issues, counsel number 2 seeks permission to move ahead with the further contentions.
You may move ahead.
Much obliged, Your Honor.
The counsel seeks permission to address the bench as your ladyship.
Yes, proceed.
Much obliged. Issue number 3. Whether the accused are guilty of causing disappearances of evidence. In the present case, the accused are not guilty of causing the disappearance of evidence as provided under section 201 of the code. The body found under the floor was retrieved on 24th of November and the date of death is shown as 9th of November. But all the facts and circumstances leads to the conclusion that the date of death had certain discrepancies. Similarly, the accused number 1 and accused number 2 have taken all steps to hide the body and all evidences related to the crime as per the prosecution. However, the evidences like the butcher's knife, the box of tiles, construction tools, blood-stained gunny bags, etc. were all easily available. If the accused were to cause disappearance of evidences, they would have taken all necessary measures to not leave behind any traces so that no case could be made against them. And as a man of common conscience and rationality would do so. The evidences found in this case were easily available in plain sight, and it does seem like they were deliberately kept there to cause trouble to the accused. The evidence found also cannot prove that the crime was committed by them, as there has been no further investigation conducted to find out whether these weapons or tools were used by them to commit the crime. The knife should have been checked for prints and the group and the type of blood and whether the same belonged to the victim. Similarly, a statement from the experts or FSL is required to prove that the same weapon was used for committing the crime. The FIR report states that the crime was committed on the 9th. Any man of ordinary prudence would take efforts to clean the knife after committing the crime. And here the accused are being framed to have allegedly committing a grave offense. It is not possible that they would not take any efforts to clear all visible signs if they would have committed the offense. Here the counsel would like to take a reference of a precedent to support the current contention. In the case of Kajula versus State of Rajasthan, it was stated that charge of causing disappearance of evidence, the crime has not been proved beyond reasonable doubt against the accused appellant, thus entitling him to benefit of doubt. In these circumstances, conviction of the accused appellant and alone recorded under section 201 IPC cannot be sustained. In VL Tressa versus State of Kerala, having regard to the language used in section 201 IPC, the lodges of the Supreme Court noted the following ingredients as a test for conviction under section 201 of the IPC. First, was the committal of an offense. Second, that the person charged with the offense under section 201 must have the knowledge and reason to believe that the main offense has been committed. Third, the person charged with the offense under section 201 of IPC should have caused disappearance of evidence or should have given false information regarding the main offense. And lastly, the act should have been done with the intention of screening the offender from legal punishment. It is to be observed here that the second and third condition of the same is not being fulfilled in this case. The council seeks permission to move forward with the fourth contention.
Yes, you may proceed.
Much obliged. Whether the accused have satisfied the condition of actus facit reum nisi mens sit rea. Intent is a crucial deciding factor that plays a major role in determining an offense. Most of the offenses committed are always backed by intent. In the present case, there was no mens rea present with regard to the accused, that is Surekha and Mohan. The council would once again like to take a reference of a precedent to support the contention. In the case of Pandurang Bahale versus State of Maharashtra and another, it was said that it is a cardinal principle of criminal jurisprudence that the prosecution is to prove the guilt of the accused beyond the possibility of any reasonable doubt. It is also a settled principle that though there might be an element of truth in the prosecution story against the accused, but considered as a whole, there is invariably a long distance to travel, and whole of this distance must be covered by the prosecution by legal, trustworthy, and unimpeachable evidence before an accused can be convicted. Despite the various instances that reflected about the close relationship between Surekha and Mohan by a few witnesses and circumstances, it cannot be proved that they had an illicit relationship between them. Rampal had always been away for most of the time as per the facts, and this left Surekha on her own. Coincidentally, Mohan, being a single parent, found a friend in Surekha, and the two of them shared their experiences through conversation for passing time. To witness two of them together in the mohalla does not necessarily point towards any sort of illicit relationship. For a single parent or for a woman to be seen spending time with another man is always considered to be immoral by the society, and the rumors keep flowing. The same scenario was faced by Surekha and Mohan. This can also be observed through the fact that when she was confronted by Rampal about the rumors, Surekha gave a very practical response, as would any person who is innocent of the same. On the day when Rampal saw Surekha and Mohan together, Mohan had simply taken it upon himself to assist Surekha for changing the tube light as per the fact sheet. The 5 minutes taken by them to open the door may raise a few questions, but that does not signify or prove anything. It is just a speculation that one may assume in such a circumstance. Moreover, if there was indeed an illicit relationship, then Rampal would have observed some fuss on the opening of the door, yet everything was normal and natural. If Surekha and Mohan had something going on, they would have made an attempt to hide or cover the situation, but they didn't. This leads us to the conclusion that there was no illicit relationship between the two, no conclusive and evident scenario that proved the same. On the discovery of Rampal's body beneath their bedroom, the only logical direction that everyone started to talk about was the intent based on having an illicit relationship between Surekha and Mohan. Any man or woman is sane enough to not commit a murder of their spouse for any illicit relationship that they would have. Taking the above statement into practice, that if Surekha and Mohan indeed had an illicit relationship going on, they clearly had no motive to kill Rampal. Both of them are sane and intelligent enough to pursue the legal way for carrying on the relationship or converting the same into marriage. They would have opted for divorce. Having an illicit relationship does not join any logical link or circumstantial evidence that would lead them to commit a murder in such a gruesome manner. By the above contention, it can be observed that Surekha and Mohan had no illicit relationship, and even if the contrary was true in any way, the same can in no manner be linked as an intent to commit such a gruesome murder, especially when there is no evidence to support so, just pure speculations and convincing theories. If your ladyship is satisfied with the current contention, the council seeks permission to move forward with the prayers.
What do you have to say about the dead body being found in the very house where they lived?
Your
The
lordship,
chopped, in a chopped way, the chopped pieces, they were chopped into 3 pieces, and that dead body was found in the very house where they used to live. What do you have to say about that?
your ladyship, that is also the same question which the defense itself has, and the same would be further proven during the cross examination.
Well.
If your ladyship permits, can the defense move forward with the prayers?
Yes, you may move forward.
Much obliged. In the lights of arguments advanced, authorities cited, and facts stated by the defendant humbly submits that this honorable court may graciously adjudge to find and hold the accused to be innocent for the allegation under section 302 read with section 34. Find and hold the accused to be innocent for the allegations under section 201 and to acquit the accused from all the charges and pass any order which the court may deem fit in the interest of justice, equity, and good conscience. That is all.
Very well.
Your Honor, the counsel seeks permission to begin with the cross-examination.
Yes.
Much obliged, Your Honor.
I object, my lord. Ma'am, actually, until and unless prosecution proceed with the chief, defense can't proceed with the cross.
You have already examined witness. No, for examination in chief, you have already conducted. You have
I apologize,
conducted
ma'am.
examination in chief of that eyewitness, the IO, and one more witness.
I apologize, ma'am. It was oversight.
Yes, you may continue with your you may start with your cross-examination.
Much obliged, Your Honor. Your Honor, the very first witness that the defense seeks to call is Dr. Ajay Matre, prosecution witness number 6.
Am I audible?
Witness not clearly.
Hello.
Yes. Sir, could you please state your full name and your occupation?
I'm Dr. Ajay Matre and I am senior in autopsy and forensics.
So for how many years have you been working in this profession?
Around 28 years.
Okay, 28 years. Doctor, could you please explain the 5 stages after death and the time duration required for each stage to complete?
I don't recall it right now.
Doctor, does it imply that you have been in the profession for 28 years? You yourself have prepared the forensic report that states autolysis, rigor mortis, but you cannot explain the 5 stages of death?
Can you please repeat?
Absolutely. Doctor, the defense would humbly like you to explain the 5 stages of death and the time duration of each stage.
Unfortunately, I cannot disclose this information.
Okay, this information cannot be disclosed.
Yes.
But doctor, it can be put in the forensic report.
Well, the only thing that was put was needed, and that was the rigor mortis of the deceased.
Okay, doctor.
Yes.
Doctor, the next question is, was there any transfer of DNA on the body of the deceased when you analyzed the body under the fingernails or any hair?
The particulars were not analyzed.
So the analysis was incomplete. That is to be inferred.
I have already mentioned everything in the report which was needed.
Indeed, doctor. Doctor, were the weapons sent to the forensic lab for analysis?
Yes.
Okay, doctor, did you check the weapon as well as the body of the deceased for fingerprints? Which kind of a weapon was used? How heavy was the weapon?
I again repeat that everything which was needed is mentioned in the report.
Okay, doctor. Doctor, just one last question. Did you take the sample of the fingerprints of the accused before starting your analysis?
No fingerprints were taken.
Okay, doctor. Thank you. Your Honor, the next witness that the defense seeks to call upon is Investigating Officer Jayant Pawar, prosecution witness number 5.
Proceed.
Much obliged, Your Honor.
Hello, am I audible?
Yes. Sir, could you please state your full name and your designation?
Inspector Jayant Pawar, Inspector of Police.
Sir, can you please name what all evidences did you find?
3 goonie bags with bloodstain on it, dismembered body parts, a butcher knife with bloodstain on it, a construction tools, a box of used tiles, and a goonie of cement.
Okay. So did you send them to the FSL, the Forensic Science Laboratory?
Yes.
Did you get a report about the fingerprints on the knife, on the gunny bags, the
No.
blood stains, whether it belonged to the victim?
No.
Okay, that's all. Thank you. Your Honor, the next witness that the defense seeks to call upon is Komal, prosecution witness number 2.
Proceed.
Much obliged, Your Honor.
Hello.
Yes. Could you please state your name and your age, Komal? Full name.
My name is Komal Rampal Singh. I am 11 years old.
Okay. Komal, you do understand the meaning of oath as per what my learned friends had asked you?
Yes, the previous sir has explained me.
Okay, Komal, perfect. Komal, can you please tell me the names of both your parents?
My father's name is Rampal Singh. My mother's name is Surekha Singh.
Okay. Komal, what does your mother do?
My mom is a housewife and a tuition teacher.
Okay. Komal, you go to school, right? In which standard are you in?
I am in 6th standard.
Okay, Komal, what time do you go to school?
I have morning classes.
Okay. Does your mom prepare a tiffin for you to take to school every day?
Yes.
Okay, Komal. And Komal, what is your favorite dish, food preparation?
Anything non-veg.
Anything?
Anything non-veg.
Okay. And Komal, does your mom prepare non-veg for you on frequent basis?
Yes.
Okay. Komal, I got to know that you go for karate classes as well. Who drops you to the classes, Komal?
My mother.
Okay. And she waits over there till your classes are over?
I have no idea. When the class gets over, she will always be there.
Okay, Komal. That's all. Your Honor, the last witness that the counsel for the defense seeks to call upon is the shopkeeper who sold the butcher's knife.
Proceed.
Sorry, the shopkeeper is not on the witness list as per the clarifications, my lord.
Indeed, noted. Your Honor, the counsel would like to humbly submit to the Honorable Court to please take note that the seller of the butcher's knife's statement was not recorded. He was not called by the prosecution to even give a statement. Therefore, my learned friends are also misleading the court whether or not the butcher's knife was bought that day. The Amba Medical's owner was called. Why was the butcher's knife, the seller of the butcher knife, not called? This does not clearly fit the chain of events. Your Honor, on basis of the cross-examination that we have conducted currently, the counsel for the defense would like to just state before the Honorable Court that the forensic report has many loopholes. It has many mistakes, and the doctor who's been in profession for 28 years cannot give answers to basic questions. The analysis is incomplete. The doctor is not well versed with his findings. Similarly, the police officer, the investigating officer, has not been following the procedure of due diligence. There needs to be a fingerprint report and everything. Lastly, Your Honor, Komal states that according to Komal's statements, her mother seems like a very caring person. She cooks her favorite meal regularly. She gives her tiffin for morning classes. She leaves her for karate classes. She's there for 3 hours since the class is going on. She picks her up from the classes. Similarly, the witnesses contradicted their statements, saying and that the mother has threatened to kill her. Your Honor, no mother would want to harm their own child in any way, let alone threaten to kill their own child. That is all from the defense's side, Your Honor, and the counsel for the defense would like to humbly state that the accused, the alleged accused in this case, are not guilty and must be acquitted of all charges. Your Honor, just one more statement that witness number 2, Komal Singh, had stated to my learned friends of the prosecution is, "Mujhe kuch nahi pata," which clearly states she does not know anything. That is all for the submissions from the counsel number 1 side, Your Honor.
With your ladyship's permission, the defense would like to call I officer Jayan Pawar.
Yes, you may proceed.
Much obliged.
Hello, am I audible?
Yes, you are. Sir, I have various questions. First, why was Rampal's phone not tracked?
It was not traceable.
Why was it not traceable? What was the issue? If I may reframe the question, what was the issue which was faced by the department that it was not traceable?
I cannot disclose this.
What was the last location where it was active?
Could you repeat it?
What was the last location where it was active?
This report is in process.
It is in process. Okay. Sir, would you say that fingerprint scan, blood sample, and DNA testing is very important as an evidence?
Yes.
Then why was the same not done during your investigation?
This is not under my jurisdiction.
Sir, where did you find the deceased body?
At his place, at the crime scene, under the bed.
Sir, did you think that it was enough evidence to reach a conclusion as you found the body as pointed out by Komal?
Yes, according to the prima facie, yes.
So would you say it was because of this judgment of yours that you did not go for fingerprint, DNA, or blood samples?
I will repeat that it is not under my jurisdiction.
But it is, of course, your duty to put forward the evidence for forensics. Am I correct?
It's not in my role.
It is not my role.
It is the doctor's role.
How many cases have you solved so far, sir?
I don't recall, but there are many.
Can you share an estimate?
I don't recall a number. There is a number.
Okay. Once again, reminding you, since you are under oath, sir, have you faced any irregularity in the past while doing any investigation?
No.
Okay, that will be all. The defense, with your ladyship's permission, would now like to call upon Kashinath.
काशीनाथ कोमल को बुलाया जा किसी का आ रहा है आवाज
Am I audible?
Yes, you are. Kashinath, how often did Surekha visit your medical shop?
Quite often.
And how often did she purchase the sleeping pills?
Repeat. Can you repeat question?
How often did she purchase the sleeping pills?
Quite often.
On the day, on 9th of November, when she visited your shop, how was her mood?
Normal.
Okay. Did you, at that time, while looking at Surekha, feel that she was in a state that she would murder someone?
No, I don't know because I'm busy with the customer on that time.
But you said that she was in a normal mood. So
Normal.
isn't this contradictory?
General normal.
Okay. One last question. How many other people used to buy Zelpodium tartrate sleeping pills in past year from your medical shop?
I don't remember.
But you have to keep a count of the stock. So I think surely you must remember if you have at least 1 or 2 customers apart from Surekha.
Around 5 to 6.
Around 5 to 6. That will be okay. The defense would now like to call upon Arun Singh with your ladyship's permission.
Yes, proceed.
Much obliged.
Yes.
Hello.
Mr. Arun Singh, when did you come to Mumbai?
On 19th November.
Okay. And did you notice any irregularity that was going on?
Yeah, when I met with Surekha, my sister-in-law, so I just found something fishy over there because the way she was expressing was really very in a afraid manner, scared manner. So just I found something wrong is going on over there.
Can you describe what was fishy according to you?
Due to her facial expression, she was very afraid. So that's and she has given me unsatisfied answers. So that's the reason.
So according to you, was she afraid because her husband was missing, or was she afraid because of some another reason?
I can't say this because I don't know the actual fact.
Okay. During the time when you visited Mumbai, how much interaction did you have with Komal?
Yeah, as she is my niece and also my daughter, so I had a casual uh, interaction with her.
And after filing the missing report, or during the days when you were concerned about Rampal, how often did you mention about Rampal's absence or the probability of his death in front of Komal?
Sir, can you reframe it?
I'll reframe it. When you filed the missing report, how often did you mention about Rampal's absence or probability of his death in front of Komal?
Uh, on 24th November, I had a casual conversation with Komal. Then she told me about the situation.
No, what I mean to ask here is, I'll repeat it again, that how often was this mentioned in front of Komal?
BTM03 speaker 2, your time is up, sir.
Your ladyship, if I may get 2 more minutes to conclude my cross-examination with your permission.
You may continue.
Much obliged. So, Mr. Arun Singh, coming back to the question, how often did you mention about Rampal's absence or probability of death in front of Komal? Let's say you are talking with Surekha. So, how often did Komal overhear that?
Yeah, I was busy to inquire about my brother, so there was a little bit interaction.
Okay. Did Komal give you any statement?
Yeah, on 24th November, she had given me the statement.
And what was the exact statement? Again, once again, reminding you that you are under oath. What was the exact statement that she gave it to you before it went to the investigation officer?
Yeah, when I asked her about his father, so suddenly she started crying and in a very worried manner and afraid manner she said me that मुझे कुछ नहीं पता जैसा मम्मी ने पापा को बैठ के नीचे डाला वैसा मुझे भी डाल देगी. And I was shocked after hearing that statement.
Noted. And were you present while the investigating officer was recording Komal's statement?
Yeah, I was there.
Okay, that will be all.
Thank you.
With this, your lordship, the defense wants to prove a certain points. While cross-examining, while cross-examining IO officer Jayan Pawar, he mentioned that it was because of his judgment that the evidence which was put forth in front of him and the circumstantial evidence that was present as per only the statement of Komal, he did not conduct or he did not move forward the fingerprint, the DNA and the blood samples. Further, it is also to be noted that Kashinath mentioned, the medical owner mentioned that around 4 to 5 people used to buy zolpidem tartrate sleeping pill from his medical shop. Here, once again, the defense would like to mention what my co-counsel has mentioned earlier, that the death, according to the forensic report, took place on 9th of November, and the body and the forensic report was done on 25th of November. The evidence collected brought forth only 4 pills from the 2 strips of the sleeping pills. Each strip has 10 tablets of the sleeping pills. That means in total there were 20 tablets which was purchased by Surekha. And this means between the gap of 9th of November and 25th, there are 16 days. So it is very safe to assume that 16 days and 16 pills were consumed by Surekha herself. And that's why in evidence, they only found 4 sleeping pills. With this, the defense rests their case. Thank you a lot, ladyship.
With your honor, permission, the prosecution would like to rebuttal.
Yes.
Much obliged. As my learned counsel said that Komal is a schizophrenic patient, I mean early stage. I guess she goes for karate classes, and in karate classes, an individual uses the hand, feet, and elbow for self-defense and needs concentration and focus. Whereas the early stage of schizophrenia says that deep sleep or insomnia, forgetfulness, unable to concentrate are few symptoms. Whereas unable to concentrate contradicts the statement of going to karate class. Secondly, Komal gave the statement that that was on recorded by the police officer on 24th, that the body of her father was dug under the bedroom, under the bed, was done on 9th. The crime scene was on 9th. So it had been 16 days and she was already able to recollect the statement of what her mother said and where the body is. So this contradicts the forgetfulness of symptom. And I would also say that oversleepness or deep sleep is also a symptom of early stage, where I guess she was woken up with this screaming sound. If the person is in deep sleep, then even the screaming sound cannot help to wake the person up. She got woken up very easily. That means she had a normal sleep schedule. These all things contradict. And may it please the honorable court, it is a settled principle of law that in the scenario of inconsistency between expert's opinion and testimony of a witness, the testimony of an unimpeachable witness overrides the expert's opinion. And with your permission, my co-prosecution would also like to proceed with to prove the illicit relationship of the accused number 1 and accused number 2.
Very well.
Much obliged, ma'am. Ma'am, since as my prosecution friend explained that the eyewitness Komal is not a patient of schizophrenia, because accused number 1 has used this statement as per their cold blood murder planning to and gave a false statement in front of the court. So that is our first thing. And secondly, about the intention and motive of accused number 1, accused number 2, proving that they were in illicit relationship, proves that, ma'am, like accused number 2 used to give gifts to accused number 1. Any relation providing gifts happens only on any occasions, and randomly providing gifts happens only and only in a paramour relationship. Secondly, Mohan used to give that, which shows Mohan has affection for Surekha. Accused number 2 has affection for accused number 1. Secondly, from accused number 1 side, she used to accept those gifts from accused number 2, which states that she accepted the affection from accused number 1 and they were in an illicit relationship. About proving, like Surekha, when Mohan, if Surekha wanted to prove to, if she cared about Mohan and she cared about her relation, the time when deceased Rampal asked Surekha about the rumors, that was the early stage when deceased got some rumor, got to know about rumors, some about her, about his wife, accused number 1 and accused number 2. That time when deceased asked to Surekha, accused number 1, about the rumors, she evaded the question and provided unsatisfactory answer to the deceased, which shows she was hiding the relationship of her and accused number 2. This proves they were in illicit relationship. We conclude with this, ma'am, that proving that Komal is not a schizophrenic patient and there was a motive and intention with accused number 1, accused number 2 to kill deceased so that they can get together in future and live a happy life. We conclude with this, ma'am.
Your Honor, the counsel for the defense humbly seeks your permission to begin with the sir rebuttal. Much obliged, Honor. Your Honor, it can be inferred that the death did not take place on the 9th since the stage of putrefaction has not commenced. This means the death has taken place between 19th to 24th of November during Arun's arrival in Mumbai. The counsel for the prosecution is also misleading the court by talking about the difference in the tiles. There is also no clear proof that the alleged accused did purchase the knife because there is no alibi to state the same. The point of illicit relationship is only based on rumors. It is not true. No one has admitted that there was any illicit relationship. Moreover, my learned friend states that accused number 2 used to gift accused number 1. Your Honor, it is humbly brought to your attention that those were not gifts. Accused number 1 was the tuition teacher for accused number 2's son. The thing that he used to give her was consideration for the tuition fees. There was no acceptance of gifts in any which way whatsoever. The next point that the counsel would like to begin with is Arun was present in Mumbai from 19th to 24th of November. He too was residing at Surekha and Rampal's residence as he is their brother. How is it that he is also not aware of what was going on and then he himself is putting the blame on his sister-in-law that she has committed the murder? Your Honor, the body was disposed of, but the other evidences were available in plain sight. This shows that if the alleged accused wanted to commit the murder and get away with it, they should have disposed the other evidences also. No human conscience would leave other evidences just lying in plain sight and only dispose of the body. The next part is my learned friend spoke about karate classes. Your Honor, it is humbly brought to the attention of the Honorable Court that some kind of a physical activity is imperative for the growth of mentally disabled patients to increase their cognitive skills. Also, they say that she did not have schizophrenia. The defense has medical reports available to prove that she has schizophrenia. My learned friend also stated that the victim asked accused number 1 about the illicit relationship, the rumors about the same, and accused number 1 did not give any satisfactory answers to the same. Your Honor, it is humbly put before the Honorable Court that the deceased is not available to prove or to concur his satisfaction for the statement. This is just a statement made by the counsel of the prosecution. With this, Your Honor, the counsel humbly submits that the prosecution are not able to prove beyond reasonable doubt that the accused have not committed the offense, and therefore we implore the Honorable Court to acquit the alleged offender, acquit the alleged accused for all the said charges. With your permission, Your Honor, Counsel 1 would like to call upon Counsel 2 to continue the further sir rebuttal.
Time up.
Yes, you may continue.
Much obliged, Your Honor.
Much obliged, your ladyship. As my learned friend mentioned, that Komal is not suffering from schizophrenia. It is being mentioned even by accused number 1 statement that they can provide the relevant documents for the same, and it can be further submitted at a later date if your ladyship permits. Second, the defense would once again like to bring to the notice that as per the cross-examination done of IO officer Jayant Pawar, he clearly stated on record that it was because of his judgment that the circumstantial evidences and that the statement of Miss Komal was enough to prove the conviction of accused, that he did not carry DNA testing, fingerprint testing, and the blood sample. Your ladyship, the defense would like to mention how important DNA testing, fingerprint testing, and blood sample is. The defense would like to take a reference here. The infamous serial killers of all time, like Ted Bundy, like Jack the Ripper in the 1900s, were a very infamous case where the accused was not being caught, the victim, the culprit were not being caught. However, it was after 1 century later, when the fingerprints, when the DNA testing, and when the blood samples and everything was introduced in the police department, that they found the killer, the real killer behind all of these events. This point is made to make emphasis on how important DNA testing and everything is, and the same has not been done in this present case. With this, the defense rests and would like to prove that the prosecution has not proved beyond reasonable doubt about the said case. That is all, your ladyship.
With with your honor, permission to answer a few questions of my of my learned counsel.
Yes.
Much obliged. I would like to say that about the reports of schizophrenia that the petitioner, prosecution witness 2, that is Komal Singh, is a schizophrenic patient. Her mother said that they will submit the reports. I guess they had enough time to forge the reports, and that might be the plan of their. Hello, am I audible?
Yes, yes, you're audible.
Hello?
You're audible.
Okay. They can forge the documents in this time span that they have, and that must be that that must be their part of plan of making the child as schizophrenic, as she was the only eyewitness. And secondly, I would just say that the counsel is misleading the court on the basis of what accused said, because there is no any documents that was submitted for the reports that was submitted on schizophrenic, and it is not even mentioned anywhere in any one statement above. And being the thing of Arun Singh, that he was also residing with the accused 1 and petitioner witness 2 from 19th to 25th. I guess they are residing separately from from past 1 year. So Arun is not supposed to know whatever things are there in their house and where the things are kept in their house. Or is there any something difference in their house, which it was earlier and later on, because the crime was committed on 9th before arrival of Arun. That's all from my side, Your Honor.
Your Honor, will the counsel also get permission to answer the questions raised by my learned friend? Your Honor, you're on mute.
1 minute. You have already, the prosecution started with the case. Thereafter, they examined the witnesses. You argued on behalf of the defense or the accused. You also cross-examined the witnesses. Then again, they have rebutted. Now again, sub-rejoinder is not allowed in criminal trial. That's all.
Indeed, Your Honor, noted. We are very grateful for your
yes, but only one thing I would like to say is none of you have referred to the very, what do you say, the important cases about death sentence, Bachchan Singh's case and Machi Singh's case, where the Supreme Court has laid down what are the mitigating circumstances and what are the aggravating circumstances. That none of the participants have addressed on that. I think these basic cases you ought to have referred, especially prosecution, and you should have pointed out what are the aggravating circumstances and what were the mitigating circumstances due to which you are saying that death sentence should be imposed. So that was missed out. Anyhow, you people have done your best, and I wish you all the best for whatever efforts you have put in moot court. I expect that all of you would be a good lawyers in future, and wish you all the best. I wish even the researchers who have helped you out for this moot court. But these were the basic, the judgments about death sentence. There is one more case law of Ravindra Chakmal versus State of Maharashtra, which was where similarly the body was chopped of his wife, and he was sentenced to death by High Court, which was confirmed by High Court, by Sessions Court, then High Court. But the Supreme Court said no, his death sentence was commuted to life, but without any remissions, without any other concessions like parole, furlough. He is not supposed to. He is going to remain in jail throughout his life till his death. So these case laws, I think you people were short of time. This was not, referred to, which you ought to have referred to. And about schizophrenia and all, it is not only arguing, but you have to bring some material about schizophrenia. If the witness is suffering from schizophrenia, it is not merely arguing the matter, but in evidence it should come that the person is schizophrenic, and therefore that witness cannot be relied upon. Then a defense harped upon gunny bag and the articles. There was no fingerprints and there was no DNA test, and all those arguments were advanced. But with my experience, these are all corroborative evidence. The substantial evidence is of the witnesses. Then if there is no corroboration, then in those cases, the Supreme Court judgments are, High Court judgments are that you can't prove the case beyond reasonable doubt, and therefore the person should be acquitted. So this all should be kept in mind when you practice criminal law, or now presently when you people are studying criminal law, especially IPC, CRPC, and Evidence Act. So all this should be kept in mind. So I wish you all the best. You have done your best, and I congratulate all of you participants, including the researchers, for doing your best for this moot court.
Thank you so much, ma'am, for your guidance. I request our IC principal, just a minute. Thank you so much, ma'am, for your valuable guidance. I now request our IC principal, ma'am, to have a few words to our honorable judge of Moot Court.
Yes. Thank you, Sharanya. Thank you so much, respected madam, that today you have imparted your knowledge with the participants and also with our students by correcting them how the proper process to be followed by them in the court of law, that they should take the they should remind the IPC and CRPC, because these are the Gitas for us, and they should remind this wherever they will approach before the court. Also, you have guided them by giving various case laws, that whenever such kind of process has to be handled by them, they have to produce the case law, they have to take the basis of this case law, so that they can definitely prove the matter before the court very easily. It will be helpful for them also and for the honorable court also. So really I'm thankful, madam, that you have guided our students, and definitely you have corrected them also, so they will improve in future for the upcoming competition. So I'm really thankful for you, madam, for your presence today. Thank you, madam.
Thank you, madam. Thank you very much. But I would like to add one thing. The participants have really done very good. I think much better than some of the advocates who argue in the court. So
Yes.
I wish them all the best.
Thank you so much, ma'am.
And they are all upcoming lawyers in future. I really wish them all the best.
Yes, ma'am.
We'll definitely look up for the great learnings given by you, ma'am, in future.
Yes, yes. These are the basics which you should know. When you stand up and argue before the court, some basic things which you should know. Like one participant was saying petitioner. In criminal law, there is no petitioner, there is no defendant. It is always state of Maharashtra or state versus the accused. So those are basic things
I
which
really
you
apologize,
learn
ma'am, for this.
when you start with your practice. There are practical things which you learn. So it's okay, but then as a student, you have done your best, and the researchers have also done their best. Some case laws were cited by some of the participants. I think they've done their best.
Thank you so much, ma'am.
Thank
I
you,
will
ma'am.
now request our honorable judge of Moot Court to declare the results of all the competitions we've had. Ma'am, please, can you do the honors for us?
You want me to declare these 4 participants whom I heard. You want me to declare who is the winner and who is the runner-up, right?
Yes, ma'am. And the results of the other competitions that I have sent you, ma'am.
1 minute.
Yes, ma'am.
Yes, I would declare that VTMO3, they are the winners, and VTMO5, they are the runners-ups. All the best.
Thank you, ma'am. Thanks a lot.
Yeah, and the
Thank you so
best
much, ma'am.
speaker is from VTMO3, speaker number 1. All the best, all the best. I would say that speaker number 2 was equally good.
Thank you so much, ma'am, for the results.
Thank you so
Thank
much,
you, ma'am.
ma'am.
Was
And
also
congratulations to
equally
VTM03.
Yes.
Yeah.
PTM 05, I would just like to state, competing against you all is a very, very difficult task. We are facing you for the second time. It was all tooth and nail. Really commendable.
But
Thank
I
you,
will
thank
tell
you.
you one thing, since I appear for the prosecution side, I believe that in the next moot court, VTMO5, who were appearing for prosecution, will do much better than what they have done now. Okay? All the best to you.
Sure, ma'am. Sure, ma'am.
Definitely, ma'am, under your guidance.
Yeah.
Thank you so much.
Ma'am, I would request you to announce the results for
Okay.
the other competitions as well, ma'am. Please.
I've declared the results. I said that VTMO3 are the winners and VTMO5 are the runner-ups. Best mooter is VTMO3, speaker number 1. Winner for C Spot Say competition is VTS02. Winner for Think Logically competition is VTT02. And winner for Law Quiz competition is VTQ04.
Thank you so much, ma'am. Thanks a lot for your precious time and guidance, and also for the results, ma'am.
Welcome.
I would now request our accuracy coordinator to please come up and give the vote of thanks.
Thank you so much. A very good morning to all the dignitaries, participants, and dear students. I, Assistant Professor Amal Salve, feeling extremely honored to extend formal vote of thanks on this occasion. VidhiTaksh 2021-2022. It was indeed a great experience of 3 days. Days of joy and excitement. Yes, a bit emotional moment. Yes, I am talking about our 3 days we spent together, and I am 100% sure that all the students agree with me that we are going to miss all these 3 days. We had a great experience, but we will definitely come again. A big clap for our fest. We will definitely looking forward for hosting the next year VidhiTaksh 3 for 2022-23. And I'm damn sure with the same zeal and this, we will definitely work together. Without expressing our gratitude towards the efforts of some people, we cannot go ahead. Firstly, I would like to express my sincere gratitude to our very supporting management, Dr. Rajendra Singh sir, President of Hindi Vidya Prachar Samiti, Dr. Usha Mukundar ma'am, Director of Hindi Vidya Prachar Samiti, Dr. Himanshu Davda sir, IC Principal of RJ College. A very special thanks to our Honorable Principal Madam, Dr. Mrs. Madhura Kalamkar Ma'am, for staunch support and valuable guidance. Please clap loudly for her, because ma'am has supported us and she is a highly motivation to us that how single person can handle so many tasks. She is a multi-dimensional personality. I would like to thank our teaching faculties, starting with Mrs. Aisha Gusakar, a person with a high energy. 3 days we have experienced it. Tejal Chaudhary ma'am, with our court committee, and she has supported a lot. Our Greta Castellino ma'am, all the technical aspects she has handled. Miss Evita Fernandez, for the Think Logical competition, she has contributed a lot. I would like to thank Miss Neha Naik also, because you have seen our social site are very highly digitalized, and our Instagram stories, and she was mind behind it. Thanks to all non-teaching staff also for their support, technical team also. And now the list of all the heroes who work behind the curtain. So give me much more time, because now I'm thankful to our entire team. Sharanya was General Secretary of the college. Big clap for her. Miss Vidhi Gupta, Deputy General Secretary, for working for brochure coordination. Reena Kotian, Treasurer, the big task of managing for the funding. Siddhi Sawant, the cultural head, she was also involved in coordination brochure. Devesh Singh, yes, cultural head, plus he was our witness also, and he has coordinated very well. Supriya Chauhan for the brochure event management work. Kajal Shukla, please clap should be going on, because these are our heroes behind the curtain. A very important team which always work behind the Moot proposition. Shivang Tiwari, Narayan Mishra, and Shreya Iyer, these three prepared the Moot proposition, on which 3 days we were discussing a lot. Then Nishi Sinha and Gaurav Begani, these two people were behind the scenes for questions. A big work of registration calling. Disha Deshmukh, Afroz Syed was also the part of that team. Sania Ahmed was also part of the team. Prachi Kokane was also part of the big clap for the registration team also. Muskan Khan for the coordination with the volunteering, and a very promising team of witnesses. The Chanchal Singh, Misbah Beg, Jai Singh, Isha Singh, and Devesh Singh. Even Yash Chavan was also the part of the witnesses team. Then we are coming to the brochures and volunteering team. Riya Gupta, Zeenat Mirza, Gulab Sheikh. Suraj Mishra was there for technical aspect, photography. Sana Sheikh was there for volunteering. Shreya Sharma, they are our timer team. Shaheen Siddiqui was a part of the team. Chanchal Singh and Jai Singh, they were the part of giving training to our witnesses. So you people have seen how the witnesses were prepared, and even the big brain behind it was Reena Kotian, because one day she was training all the witnesses. Last but not the least, Vandana Pandey for the brochure distribution. Last thanks to all the participants who has joined our competition. And first day of the competition, I said it, that yes, this is a moment that we should leave it. And we lived, and it is actually, rest is the history. So thank you so much for the VidhiTaksh team of 2021-22, and we will definitely come again next year. Thanks a lot. Have a good day.
Thank you so much, sir. That was indeed really kind of you. And coming to the end of the program, I request everyone to please rise up for the national anthem.
हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे नव जय गाथा जन गण मंगल नायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you. Thank you, everyone. Have a good day.